The appeal court, the 3-member panel, in a 2-1 split decision said no. The dissent came from the Chief Justice of the province of British Columbia. Nevertheless, the judgment was overturned. On October 15th of this year, less than 1 month from today, this case goes once again before the Supreme Court of Canada. The only judge left from the original panel is our Chief Justice, Beverly McLaughlin, who at the time of the original decision was in dissent. In addition to that initiative, one of our members of Parliament, a quadriplegic by the name of Stephen Fletcher, joined by a paraplegic, Manon Perot, introduced 2 private members' bills. And those private members' bills seek to overturn our current prohibitions. In all 3 initiatives I will speak to, the prohibitions being challenged are both those on assisting a suicide, as it's legally described, and on homicide, because you can't consent to your own death. So in all cases, we're seeking both the right to have a prescription to ingest and to have medication administered by a physician. The private members' bills are broader than the court case, not requiring an advanced state of weakening capacities, but also allowing an individual who is seriously disabled to have assistance to die. But one of the things we've learned in our journey is that it sometimes only takes 1 or 2 individuals to make a difference. An individual to take a court case forward, a single member of federal parliament to make a challenge. And in our 3rd initiative, a parliamentarian, an MP, a member of the National Assembly of Quebec, she could even be a member of the opposition. But with courage and conviction, if she were to introduce a motion, amazing results could follow. And rather than me sharing with you, just briefly to give you a taste of what she'll be talking about tomorrow, here is Madame Véronique Yvon.
Thank you, Wanda Morris. I wasn't supposed to be here, but she asked me this morning just to come to give you a teaser about the conference tomorrow, so it's just obviously. I just want to let you know that in Quebec, yes, we finally, after almost 5 years of work, adopted last June a bill, end of life care bill, and this, I think, can be linked to 3 things, which I will talk, of course, a lot more tomorrow afternoon. 3 keys, I think, to the success of this approach is that first, we based our whole work on the fact that Quebec as a province, because you know that it's a federation in Canada, and so the powers are shared. We have power over health issues, and the whole approach was not one based on decriminalization, but it was really an approach based on a continuum of care at the end of life. And to that effect, we needed to have an exceptional way of handling exceptional suffering, which is medical aid in dying, as provided for in the bill. Another key, I think, to the success of the approach is that it was really an approach that involved the public. We decided to, as a National Assembly, after I tabled the motion, to accept this and to go to put a special committee in place and to go throughout Quebec in 8 different cities to hear what people had to tell us. We wanted mostly to hear what people had to say, not mainly organizations, although of course they all came, but we really wanted the focus to be on the people and their stories and their views on everything that had to do with end of life, because it was not just about medical aid and dying. Another key, I think, is the fact that we were able to work as a parliament with the different parties, the 4 different parties that are represented in the House, were able to work together on this issue. And before the bill was drafted, we tabled a unanimous report which had more than 20 unanimous recommendations to go forward. So of course that was the key to the success. And I would say that last, the key to the success, I think, is that the bill, I think it's the first bill that is really put on, framed that way, is that it's really a comprehensive bill about end-of-life care. So it is as much concerning the right to access palliative care as to advanced medical directives that have to be followed if they respect a certain form, as to palliative sedation, as to medical aid in dying. So everything is framed on a continuum, and really it is an approach that puts the patient, the person, in really at the center of the whole approach, and to see how we can accompany that person in the best ways possible. So of course tomorrow I will talk a lot more about the bill in itself, the process in itself, what went well, what was a little bit more difficult, and how we were able to do this in Quebec, although there are those challenges, although the federal government is against it, how we were able to put forward such a bill. So thank you for your attention.
I'll just share a bit more about the other 2 processes, the court case and the private members bill. We had a previous court case. What differentiated this one was the evidence. In Rodriguez, there was a binder of evidence. In the Carter-Taylor case, there was a bookcase of binders. The counsel that was hired, Joe Arve, hired by BC Civil Liberties, a charity that ran the case, one of the top constitutional lawyers in Canada. He's doing the case pro bono in the sense that he's not being paid for his time, but he's certainly asking for costs, including time, in a bill in excess of $1 million for the provincial case. He also brought in lawyers and experts from around the world so that the testimony that was provided was able to clearly refute so many of the allegations that play out in our newspapers. And one of the things, perhaps serendipitously, that happened is one of the key witnesses for the Crown was cross-examined, and on cross-examination, his testimony was found to be fundamentally flawed. Over and over and over, he had said things that were not consistent with the papers he was quoting, or were just simply wrong. So on review of the evidence, the facts were clear. Justice Smith agreed that while the evidence conflicted, she could allow assisted dying in particular circumstances and protect the weak and vulnerable. With the private members' bills, that was an initiative that we were challenged by, because one of the issues before the courts is, why should the courts rule if Parliament is actually taking care of things? If Parliament is going to write legislation, the courts don't need to rule. So we had a concern about private members' bills being introduced, but they were going to be introduced. There was no stopping this member. So we tried to work with him to shape the legislation that he introduced. And rather than a one-page bill with virtually no safeguards, we gave him a suggested outline that would meet many of the concerns that we have as an organization. He did not adopt all of our recommendations, but what he did put forward was a greatly strengthened bill over his initial couple of paragraphs. One of the challenges we've had in the past is individuals introducing private members' bills that are not well thought out, not well reasoned, and do not have appropriate safeguards. And that led to the situation we had in 2010, where we had a private members' bill go to vote. It only received the support of 20% of members of parliament, and is widely held up by the current government and our opposition as evidence that this issue has already been dealt with and should just go away. In terms of other things, I'd maybe share just a few lessons that I've learned in my last, it's been, I guess, almost 4 years as the head of Dying with Dignity Canada. One is that one person can make a significant difference if it is the right person. And it's not about getting the organization in the limelight. It's about finding a person who has a personal story, a politician who has the courage to move forward, or a doctor who is willing to publicly stand and speak out. For years at Dying with Dignity, we tried to find a doctor to come onto our board, and we were so fortunate to have not just one, but two join our board of directors. They've now founded a Physicians Advisory Council, and we have 25 doctors now who are speaking out across the country and showing their support for choice. And I think that's one of the reasons that the Canadian Medical Association, the delegates at their recent conference, a year ago, they could not pass a motion agreeing to discuss assisted dying. This year at their conference, the delegates passed a motion with 91% in support of doctors having the right to follow their conscience. And yeah. And I think that's in large part to the doctors in our advisory council who had the courage to be the first ones to put their heads up, to write letters to the paper, to show that this is something physicians do support. We also had a member who, Dr. Don Lowe, who was beloved in the physicians community in Toronto, facing a horrific death, filmed a video and made an impassioned plea for other physicians to start supporting choice. It is up to you whether you want to have and campaign for the perfect scenario that you envision, or if you want to be successful. We have decided at Dying with Dignity that we are a mainstream, middle-of-the-road health charity. We want to form coalitions and work with others, including physicians and members of the medical community. And to that end, we are moderating our language and what we are striving for. I think that is our very best chance of having a way forward. We are reframing the language, much in the way that Catherine Tucker talked about. We do not support suicide, but we absolutely believe that an individual who is dying, who's facing the prospect of a horrific death, should have the right to a compassionate assistance to die. Our language matters. Poll after poll shows a significant difference in public support between, do you think a doctor should help someone commit suicide, or do you support a patient's right to have assistance to die with strict guidelines and if it's a persistent and repeated request? The difference could be as much as 20 basis points. We, I believe, need to acknowledge legitimate concerns. I think in the past we may have been, as a movement, dismissive of the concerns of, for example, the disability community. Many of our clients at end of life have disabilities and experience firsthand what those with disabilities live with every day. The lack of access to facilities, the discrimination by healthcare professionals, those realities exist. And for us to deny them makes a mockery of the situation that the disabled live with, and also really lessens the effectiveness of our voice. What we believe, what the research shows, is that when we legalize choice, we offer something better for individuals with disabilities, better protection, and also the right for their choice and autonomy. I really hope that at some future point, we can have a dialogue with individuals with disabilities and provide a law that gives them the comfort and security that they need. I think that's the best way forward. As a chartered accountant, I've always been a numbers girl, and I think that we should not shy away from the numbers. Our opponents often talk about statistics, and they'll throw out things like there's 32% abuse here, and the Renlink report. And when I first heard those numbers, I thought, am I working for the wrong side? I remember this deep pit in my stomach. But I'm an auditor by training. I did my research, I looked at the data, and what I found is that there is life-ending acts without explicit request, but that legalization consistently reduces those numbers significantly, by half, by 3/4. We shouldn't run away from that data. We should confront it and explain it and put it out there. Many of us who are drawn to this movement say that the typical person who's a supporter is a white atheist engineer. And we like to talk about things from a very logical perspective. If we want to touch hearts and minds, we need to connect. And the way that we connect is by sharing our stories. And when you heard Sean Davison earlier sharing his most poignant story, no matter how many of those stories we heard before, we realize that is the way we achieve our breakthroughs. And are you signaling me time?
Yes.
Oh my goodness. Okay, so the last point I will make is that our best way forward is to be the voice of calm and reason. While sometimes we may feel called on to argue and be strident, all that does is cause other people listening to put up a great big wall. When we argue from the evidence, when we show the facts, and we share our stories, we are unstoppable.
We have about 7 minutes for questions, and we could go to either of the two speakers. All right. Are there questions? And remember, there's a mic in the way back. I see a hand in the absolute last row. And let's take one down here while the mic is
How
coming.
do you deal with the religious opposition?
How do you deal with the religious opposition?
One of my mentors in the movement, Sheila Noyes, said to me when I first started, said, anytime you give a presentation, 30% or a third of the room agrees with you, a third of the room will never agree with you, you're speaking to the 1/3 in the middle. And usually what I try to do with people from the religious movement is give them enough rope to hang themselves. Inevitably they will start talking about God's will and sacredness of life and redemptive suffering, and I just let that speak for itself. I have had hecklers at sessions where I've attended, and I find that if I let them go, the audience will generally ask them to leave. I have also, on occasion, depending on the community I speak to, I've spoken to humanists, for example, or students who are primarily secular, and I have outed some of the background of some of our opponents, those individuals who say that they are doctors or lawyers and this isn't a religious issue. And I've just noted their previous involvement in pro-life work that has also carried. But for the most part, it's, especially if it's the rank and file, I just let them go, and most people are not at all convinced by what they say.
Person in the way back.
I was lucky enough to go out front and talk to some of the people who were demonstrating against this conference earlier today. You directly talked about some of their very deep and real concerns, and I thank you very much for that. Can you expand on that a little bit more? Because it really sounds like if their concerns are answered, the majority of the serious concerns are put aside.
One of the speakers from the disability rights movement in Canada is Rhonda Weeb. And the first time I heard her speak, I found myself nodding my head after just about everything she said. She talked about emergency evacuation plans where able-bodied people were able to be evacuated, and those who had disabilities were asked to just please wait in a refuge area in a corner, and someone would get to them eventually. She talked about trying to get on elevators in conferences and being unable to move between floors because they were packed with able-bodied people who could take the stairs. Another friend of mine, when I first got involved with the movement, was an individual who worked with people with intellectual disabilities. And she said to me, how could you do this? You know, I've worked with individuals with Downs for ages, and one of the things we know is you never let somebody with Downs go to the hospital by themselves. A 40-year-old typical man with a kidney failure would go to the hospital and be told, okay, here's the procedure, go on dialysis, this is what happens. The same age, everything else, an individual with Downs would be told, you've had a good life, let's look at palliative care options. I think that's shameful, and so I think we have to acknowledge that reality and start to move forward. What really saddens me is my inability to have a dialogue with the disability community. I've tried to reach out a number of times and talk about what would you like to see in legislation that would make you feel safe. We've tried this with the palliative care community with a bit more success, and certainly when we look at a provincial measure that introduces assisted dying as part of health, we can tie it to palliative care funding, as Quebec is doing with an annual increase in palliative care funding of $15 million a year. I'd like to know what the concerns are of the disability community and try to do the same.
And I have to say personally, I think that last point is extraordinarily important, that we need to listen to these concerns. Our next speaker is Robert Rivas. This will be a treat. He is an appellate level attorney who is also general counsel for an outfit you might have heard of, Final Exit Network. Anybody here not aware of Final Exit Network? And practices in Florida. I think he will describe to you the cases that he's been working with. We'll take one of your screenings less.
Good afternoon. I have everything working against me. We're all at a point where it feels like nap time. Y'all want to fall asleep. And then I have the misfortune of having to follow such a compelling speaker with a compelling message as Wanda. I was inspired. I think she's terrific, and I think what they're doing there is terrific. But I'm going to press on and try to do my speech here. It's a real honor and a privilege for me to speak at this extraordinary gathering, and I'm humbled to speak before some of the world's greatest minds in the field and on the subject of the right to die with dignity. I'm going to be talking about the place where, in American law, the right to death with dignity as a legal proposition intersects with the right to free speech. They sound like such unrelated and different things, and we've managed to find some experiences that show that they really come together to be about the same thing at a certain point. I am the general counsel for Final Exit Network. Final Exit Network provides information, education, moral support, and a compassionate presence at the bedside of its members when they have chosen to hasten their deaths. As far as the law of the United States is concerned, anytime anyone hastens his or her own death, it is called a suicide legally. So I'm going to use that word today because no matter what the circumstances or the motivation, if one hastens its own death, it is the legal term for it is a suicide, and that's what it's categorized as. And we're talking here about the law. So suicide, of course, is not a crime in this country, but in 37 states of the United States, there is a statute on the books that in one form or another makes it a crime to assist in a suicide. These are not aiding and abetting laws. They're laws directly making it a crime to assist in a suicide, even though suicide is not legal, which makes them different from aiding and abetting type statutes. How does one commit assistance? What's it mean to assist? Assistance means either providing the means or providing actual physical assistance. If you provide somebody with drugs, a gun, a helium kit, you can be convicted of assisted suicide even if you're not present at the death. If you do not provide the means, but you're present at the death, you can be convicted if you mix the drugs with ice cream. Or if you hand the decedent something that the decedent couldn't have otherwise reached. Or if you set up the helium kit. These are all tangible acts of assistance. Under Final Exit Network protocols, our exit guides do not do any of these things. Exit guides do not provide assistance. They do not provide the means. They provide only information, education, emotional support, and a compassionate presence, all the while operating under protocols that require them to be careful not to violate the laws of the state where they're working. So the exit guides from Final Exit Network have no trouble with the law. Right? Can I get a witness? No, it ain't so. In 2008 and 2009, the Georgia Bureau of Investigation conducted an undercover sting operation. Dr. Egbert told you a little bit about it this morning. They had an undercover agent infiltrate the network, pretending to be dying of cancer. And they even manufactured, Final Exit Network as part of the screening process requires that people produce their medical records, and these folks had actual doctors work up phony, fraudulent medical records to submit the Final Exit Network to convince our people that this Georgia Bureau of Investigation undercover operative was actually dying of cancer. It worked, and a few of you may know Thomas E. Ted Goodwin, your former president, or the former president of the World Federation of Right to Die Societies. As soon as he finished having a meeting with the undercover agent pulled a gun on him and arrested him. The house was surrounded by agents. They put out a press release saying that they had busted, this is really, I crack up. Press release says they busted an underground nationwide assisted suicide ring. And you look around you at all the folks with Final Exit Network badges on them. Just look at them for a minute and ask yourself if you could put 2 or 3 or 4 of those folks, those geriatric, those geezers together. and call them a ring. I mean, these guys at the GBI had some sense of humor. They instantly seized $334,786.08 of the network's funds and panned out across the country, arresting Dr. Egbert in Baltimore, Nick Sheridan, he's out there somewhere in Baltimore, Ted Goodwin in Georgia, and Claire Blair, another volunteer from Georgia. They executed search warrants and ransacked the homes, in some cases, of 14 network volunteers, board members, coordinators, in Georgia, Florida, Maryland, Michigan, Missouri, Ohio, Colorado, and Montana. That was February 25th, 2009. The GBI in its planning documents called this Bust Day, uppercase. In internal documents that we obtained much later in the criminal processes called discovery, I learned that the GBI's intent was to dismantle. They kept using that word, that on February 25th, 2009, they were going to dismantle Final Exit Network. That day. They didn't think they'd ever have to try a case. They thought the very existence of the organization would cease because of the arrests and the mayhem caused by all of the GBI activities. So much for due process. They charged the network and 4 of its volunteers with, among other various crimes, racketeering. Some of you may know racketeering is a very specialized law, and it was created for the specific purpose of giving the government a powerful tool to use against difficult people to prosecute, people who are involved in criminal organizations. I mean, we're talking about the Medellin cartel, and we're talking about, in olden days, Al Capone, from right here in Chicago. These are the folks that racketeering laws were designed for, and the GBI intended to try to get folks like Ted, Larry, Nick, and Claire put in prison, potentially for life. They spent millions. Nobody obligates a government agency to go back and figure out how much they spent. So we'll never know the number, but it's staggering. Armed with the network's confidential information about its members and the deaths of members over the previous few years, the GBI went all around the country trying to get other law enforcement agencies to initiate prosecutions of the network. They'd send a letter to some small town sheriff's office and say, you have a death on your books from 2007 that you have listed as natural death. And we'd like to inform you that we have uncovered proof that it really was an assisted suicide, and we enclose all the rest of this information here for you as to how to go about prosecuting, and we're here to help if you'd like our help in prosecuting this organization. Hundreds of them all across the country. It is a great inspiration that very few law enforcement agencies in America took this bait. In fact, it's really the non-event of no other investigation. There were other investigations that didn't go anywhere, but no other prosecutions was one of the most important stories of the whole event, and it was hard to even put your finger on it because it was a non-event. But eventually, there was one agency in America that did respond with a prosecution. Don't let me forget to get back to that subject. We organized the best team of defense lawyers in Atlanta. I personally handled the appeal to the Georgia Supreme Court. During the oral argument, I stood before 7 very skeptical, this is not a court that's noted for its liberalism. Okay? I stood before these very skeptical Georgia justices, and you could sense, Larry could probably remember and tell you, there was a shift that took place. You could sense their attitude between the beginning of the oral argument and the end. It was like, they started off thinking, oh, here's more crooks with a phony First Amendment argument, and they gradually began to go, you what? And they suddenly seemed to awaken to the fact that there was really a First Amendment problem with the statute. And then the state's responses were so bad, I could have, it didn't much matter whether I was good or bad because the state was so bad that we won the oral argument. They were the best lawyers on our side in front of the Supreme Court of Georgia. Anyway, the Supreme Court threw out Georgia's statute, declared it unconstitutional, dismissed all the charges. So we win Georgia. Meanwhile, in Phoenix, 4 other volunteers were charged at the same time with assisting in a suicide. The Arizona authorities terrorized 2 of the 80-something ladies into accepting plea bargains, bargain basement plea bargains. The folks outside protesting always put up on their websites that people in Arizona pleaded guilty to serious felonies. Those are the words that they used. Not true. There was nobody ever pleaded guilty to a felony. Nobody from Final Exit Networks ever pleaded guilty to any felony or to assisting in a suicide. They gave these bargain basement plea deals to a couple of people in Arizona who couldn't stand the stress of the trial and decided to take it because they were just misdemeanors and they involved no prison time. So it puts an imperfection on our record, but nonetheless, they had a right to do that. Finally, Dr. Egbert, who was then with Johns Hopkins, and his co-defendant Frank Langsner went on trial. Trial took 2 weeks, and the jury found Dr. Egbert not guilty, and they found they couldn't reach a verdict on Frank Langsner, but they voted 4 to convict, 4 to acquit, and 1 refused to vote. So the state couldn't even get a simple majority, and they had to have a unanimous verdict. They couldn't even get a simple majority of the members of the jury to convict Frank Langsner. Dr. Egbert did the funniest thing that day. He stood up, everybody's standing up, the jury's read his verdict, the judge is talking about what happens, tells him he's free to go, and he turns to his lawyer, Don Samuel, and says something like, "What, did I hear that they didn't release Frank? Frank wasn't acquitted?" And Don says, "Yeah, Frank wasn't acquitted. He may have to have a retrial." And Dr. Egbert said, "I won't accept that. No, they can't find me not guilty if Frank doesn't come with me." Don Samuel, his lawyer, loves to tell that story. He never had a client who wanted to refuse to accept an acquittal. But again, to summarize, nobody from Final Exit Networks ever pleaded guilty to a felony. In front of juries, nobody from Final Exit Networks ever been convicted. Nobody's ever pleaded guilty to assisting in a suicide, felony or non-felony. None of them's ever been sentenced to a single day in jail. So to the extent that there are these little imperfections of people agreeing to guilty pleas. Oh, I didn't wrap that up too. Frank Langsner, going forward, the state tried to retry him. They can retry him as a hung jury. They went forward planning to retry Frank, but they offered him a plea deal that was even less than the other 2 had pleaded to. It was literally an offense that wasn't even a crime. So he took the guilty plea. He said they made an offer he couldn't refuse. Which brings us to Minnesota. That's the one that's still going on now. Remember I said that the GBI went all around the country trying to foment prosecutions, and I was going to get back to that. Well, here's where we get back to it. The one law enforcement agency in the country that took up the challenge by the Georgia Bureau of Investigation to go try to bust people for some event that had taken place that they'd seized all these records of, was the DA in a little Minnesota town called Hastings, farming community south of the Minneapolis-St. Paul area, where the DA, people in law enforcement and the judiciary and lawyers all chuckle when they hear the guy's name, because he's so infamous for questionable ethics and for being an unabashed publicity hound. And we believe that's essentially why we're charged with anything in Minnesota. Minnesota is one of only 6 states in the country where the law prohibits not only assisting in a suicide, but it also prohibits advising or encouraging. The statute says advising, encouraging, or assisting in a suicide is a crime. And so going forward in Minnesota, they thought that they were going to be able to get convictions of 4 exit guys, including, again, the ever-present Dr. Egbert. advising and encouraging, which words that are so flexible that they could be interpreted to mean exactly what exit guides do, although they never advise in favor and they never encourage. But again, those words are so flexible that you could say that we do that. Minnesota makes it a crime to even talk to your 4 volunteers. Went forward defending these charges while the state openly acknowledged that they had no evidence of actual assisting. We filed a motion to dismiss the charges because the statute violated the First Amendment. Is that minutes? I wanted to leave a lot of time for questions, and this was longer than I had thought. Let me just wrap this up by telling you that in Louisiana, the statute in Louisiana is the worst statute in the country. Not only does it prohibit advising or encouraging a suicide, but it also says that one is guilty of a crime for the providing of the knowledge of such means. Providing the knowledge of how to commit suicide is a felony. Hand somebody something. Tell somebody something. Just a matter of fact. And it's a felony. That's a direct prohibition against free speech that's even more clear than the other ones, even more clear than the one in Minnesota. So I just can't resist letting y'all in on something that's not supposed to be announced yet, but within the next few weeks, maybe a month at the most, it's not precisely finalized. Final Exit Network and the ACLU of Louisiana are going to join forces in bringing a lawsuit against the state of Louisiana for a judicial declaration that the statute in Louisiana is unconstitutional and for an injunction against enforcing its statutory prohibition on giving information about what this statute labels suicide. And Louisiana is a little unusual. It's the only American state that was once French and was once part of Napoleon's empire, and it still has some vestiges of the old Napoleonic code and things. When you make the allegations in a complaint as the plaintiff in any other state, since you're making the allegations in Louisiana, they tell you the alligator. No, they don't really call you the alligator. But we're going to be the alligators in the next few weeks in the lawsuit in federal court against Louisiana to strike down their statute as unconstitutional. So I really hope that I can look forward to at least briefly speaking to the same conference wherever it is in 2 years and telling you the update of number one, whatever became of Minnesota, it's going to be tried sometime in 2015 with the narrowed down version. You know, we won in the appeals court. The statute may now only be applied strictly for against assisting in a suicide, not advising or encouraging anymore. And in Louisiana, we'll know whether we've stricken the Louisiana statute as unconstitutional. Thank you. We got 5 minutes for questions. Good.
We have 10. Our timer says we have 10.
Splendid. I'm glad I got cut off just in time. Go ahead.
Well, I work for the ACLU, so I'm really thrilled to hear this news.
Oh, don't tell them I said this now. It's supposed to be a big secret until the day is live.
I wanted to ask a free speech related question. I want to say first, I'm so glad we're just talking about this in Chicago, because this is the city where the Jane Abortion Service provided 11,000 illegal abortions to women before Roe v. Wade. I appreciate what they did. They were also busted. I see parallels to what the final.
Oh, there's always parallels between abortion and the right to die. It's amazing how many parallels.
Can you repeat the question?
I will.
What I wanted to ask you was, we've heard maybe from Compassionate Choices and from a group in Canada about using the phrase physician aid or aid in dying. And I totally get that if that's what we're going for, it makes sense to use language that tests well, in message tests, and that the stories that change hearts and minds. But Final Exit Network doesn't limit assistance only to people who have a diagnosis of 6 months to live, right? So what are your thoughts on messaging a little bit more broadly?
We just use these words very carefully. and we try to avoid, well, Final Exit Network doesn't operate only for people who are terminally ill, in the sense that they have a diagnosis. The classic definition of terminally ill is that somebody have a diagnosis of 6 months to live. Same as the criteria for entrance into hospice. We just refuse to accept that as a definitional characteristic to obtain Final Exit Network support. We carefully don't call it assistance. Final Exit Network support in people's deaths, because with so many diseases like ALS, even cancers, you can often have somebody who knows perfectly well that they're soon going to cross the threshold, exit from the window of opportunity, and find themselves incapable of lifting a hand or doing whatever physical activities it takes to cause their own death. And we're willing to help them before they cross that threshold, even though no doctor would say that they now have less than 6 months to live. So we reject the 6-month criteria for deciding whom to assist. We use the word support. Does that answer your question? You actually asked about the known use of the term suicide. I talk a lot in different places, and I'm always talking about the law. And when I talk about the law, I just feel that I have to use the word suicide to be clear, because we're talking about laws that prohibit assisting in suicide, and I have to stick with the words that the law uses. And I kind of don't feel all that religious about the avoidance of the term suicide. I just think it's broadly understood, and I like to explain to other audiences, not this one, but to other public audiences, what we mean about suicide and why the word's objectionable, but then nonetheless fall back on using it.
What happened to the $386,000 that the feds took?
The $386,000. The state of Georgia, remember I said that they thought that they were going to destroy Final Exit Network that day? When the state brings civil forfeiture action against funds of a racketeering organization, the state has a reasonable length of time, precise length is not established, a reasonable length of time to file a civil complaint against the money. First they seize it with a court order, it's like a warrant, and then they have to file a civil racketeering complaint against it, so that the person whose money's been seized has due process. They subsequently can go back and show the court why it was wrongly seized and why it should be given back. The state of Georgia never filed a complaint. 6 months later, our lawyers filed a motion to release the funds because the state never followed up on their civil racketeering seizures, and the judge granted it. To me, it was another piece of proof that the state of Georgia thought Final Exit Network would be destroyed on bus day and never made any plans to proceed with trying their case.
Can you finish telling what happened in Minnesota?
Yeah.
In Hastings?
Yeah, we filed a motion to dismiss the complaint. The trial court agreed with us that the statute was unconstitutional. The trial court struck down the advising and encouraging language of the statute. The state took an appeal to the Court of Appeals of Minnesota. The Court of Appeals of Minnesota got it right, said we were right, said the trial court was right. The state tried to appeal to the Supreme Court of Minnesota, and the Supreme Court of Minnesota first granted review, but then discharged review without fully reviewing it. So it goes back to the trial court now, and basically the appeals court ruling is in place. So the statute's effectively been carved up so that only assisting can be applied. But we didn't have a trial before the appeals, and now we go forward as if the appeals, you sort of start back in the beginning with the trial process. That's why we're going to have a trial sometime probably in 2015. One of the judges in the Court of Appeals, a woman, looked over her glasses, looked at the Assistant Attorney General who was arguing the case and said, "Do you mean to tell me that under this statute, if I'm at my mother's bedside and she's dying, and I tell her that it would go a little faster if she just stopped eating and drinking, I've committed a felony?" And the state said, Well, in that situation, I guess it would violate the statute, and they tried to obfuscate the issue. They lost their vote at that moment. Court of Appeals decision was unanimous. And so it was a momentous decision for us.
Up here. How about some questions from the back?
All right. But that you wanted to tell considerations.
It's kind of an insider thing. Yeah, the guy with the green hat.
Guy with the green hat. Any background on why the GBI did this, and has anything happened to the GBI since then?
Any background on why the GBI did this, and has anything happened since then to the GBI? I hate to tell you, the answers to both questions are no. We have never been able to understand who got a wild hair of his ass to go bananas trying to charge final exit network in these cases. We just don't understand it. There's no evidence of anybody being a religious fanatic. We just don't know internally what happened to make them so excited. You'd think that after all of what happened, somebody would be punished. Somebody would internally would at least be blamed for having done a really stupid thing. I mean, I could have told them before they went forward spending these millions of dollars that there was, the statute was egregiously unconstitutional. The Georgia statute's nothing like the one in Minnesota. I haven't even told you what's wrong with the Georgia statute. The Georgia statute was so screwball that it was hopeless to try to prosecute us under the Georgia statute. And they did nonetheless. The government agencies are just never accountable when they do something that costs a lot of taxpayer money. They're never accountable. Thank you.
Thank you.
Thank you. I think you'll agree that this has been the whole afternoon has been a very interesting session. And to make it complete, we have one last speaker. This is Dr. Petra de Jong. And she has a particular advantage that many of the rest of us don't have. That is, she lives in the Netherlands. And not only does she live in the Netherlands, she's part of what has made the Netherlands what it is and why it's such a good place to be from the perspective of this issue. She is a pulmonologist by training. She's had a long career as a practicing physician. She has been involved in the ends and lives of, I think, 16 patients, is that right? As a lung specialist. And she is now the head of the NVVE, the central Dutch organization supporting rights to euthanasia, as it's called in the Netherlands, under the favorable understanding of that term, and also physician-assisted suicide, as it's called there, although would not be called that here. Thank you. Dr. Duhon.
Thank you very much. I would like to thank the organizers for inviting me here so I can talk to you about euthanasia in the Netherlands. But first, when I landed here, the first man I spoke to was a man who asked me, "What are you coming to do here?" And I said, "I'm going to attend a conference about what?" I said, "The right to die in dignity." He said, "Oh, that's fun." Assisted suicide. I said, "And euthanasia?" "Wow," he said. And he wished me success. But there is something, and I'm going to talk about it, it's cultural, because when I saw the demonstration today, I got confused, because I can't see what where the conflict is of disabled patients or persons that are fighting for right to live that conflicts with my intensity to have a quality of dying. Quality of dying and right to live doesn't compare for me, but that must be cultural, I think. As I didn't understand the German doctor who asked me when I gave a lecture that he said, how can a patient trust his doctor when the doctor is also doing euthanasia? I was astonished. I didn't know what to say. I'm going to talk to you about euthanasia in the Netherlands, about the NVVE. I'm going to talk about the Levenseinde Kliniek, that's a Dutch word for the end-of-life clinic. And in between, well, there are a lot of things. So maybe I can manage this myself. Yeah, the NVVE. The NVVE is founded in 1973. And their goal was legalization of euthanasia. And that goal was achieved in 2002 under strict due care criteria. And since 2003, because the goal was achieved, we changed the name and we the goal was more dying in dignity and freedom of choice. And the right to choose for euthanasia is still an issue. But the issue is supported by 155,000 members nowadays. And every day we have about 50 new members, 7 days a week. Why in the Netherlands? As I told you, it's got something to do with our culture. What we call the Boulder model and the secularization. We had some very brave doctors who helped their patient die in dignity with euthanasia, and they were willing to go to court because they had to. And those court cases made our law in 2002 in the end. We also have a social security for everybody and the healthcare for everyone. So it can't be an issue of being disabled, being old, anything on economic reasons to get euthanasia. It must be your own request. And 95% of the population, of the Dutch population, supports euthanasia. They are not against. Not of them all will ask it for themselves, but they agree that it is possible to choose for euthanasia. I will later on tell what the practice is. What is euthanasia? Well, I can tell you that that is not euthanasia. Euthanasia is the deliberate termination of life by a doctor at the patient's explicit request. Yeah? You remember this for the rest of my talk. The requirements of due care in our law are that there must be a voluntary and well-considered request. That is always needed before euthanasia can even thought about. There must be unbearable and hopeless suffering. And the source of the suffering is not important. So it can be psychological suffering, it can be suffering of dementia, it can be suffering. The patient must be informed about the situation and the prognosis. And there must be no reasonable alternative. Consultation of an independent physician is always needed, and the performance must be done following the state-of-the-art care. How does the procedure work? There must be a request, as I told you. There must be an independent doctor, and there must be a performance afterwards. How does that be done? Intravenously, thiopentol, 2,000 milligrams are injected, and that the patient have go in a coma, is in a deep sleep, because the next medication, rocuron, for 20 milligram, will paralyze all the muscles. So the patient will suffocate if he was conscious. That's the reason why a coma must be induced. And the patient will die within 3 minutes. Then the report of the doctor and the independent doctor both are sent to the national pathologist report, and he or she will report a non-natural death, because it's not non-natural. Reports to regional euthanasia review committee are sent by the national pathologist. I can't pronounce that word. The committee tests whether the due care criteria are met. And they say when they are met that the doctor will not be prosecuted, and when they're not met, it's reported to the court. And since we have the law, there hasn't been a doctor prosecuted. So since 2002. What are the numbers? Every 5 years we have, at first it was the Remmeling report, but that is old stuff now. Every 5 years we have new reports, and this one is the last. These are the numbers of death in Holland every year. This is the percentage of euthanasia performed. This is the line of the assisted suicide. This is the number, or the percentage of euthanasia without a request, and as you can see, it declines. And this is the number, the percentage of palliative sedation, and that increases. But as you can see, the percentage of euthanasia doesn't differ very much in the years, and it's only about 2.5% of all death. And we're talking a lot about it. How's that in the absolute numbers? And what I show you here is the number of euthanasias that are reported. And in the beginning, there were no doctors reporting, or only a few. And here in 2002, the number is a bit declining. And that was the year that the euthanasia law was in work. As you can see, after that, it's increasing. The number is increasing, and that is because there are more old people, but mostly it's because there are more baby boomers who know what they want in their life, and they know how they want to die. And that is what is happening here. This last year was 2012, and I expected the new numbers this week, but they are not there about 2013. And I've heard that it's somewhere about 5,000 cases. But we also have problems. We have problems in the last 12 years that euthanasia requests were done by psychiatric patients, dementia patients, and people with a completed life. And they were not honored in their request. That meant that the NVVE was often confronted with requests of people, and they said, well, I asked my doctor, but my doctor is not willing to help me. What can I do? And that number of people contacting us was so high that we said at one moment, maybe we must look for a solution ourselves. And that was the reason that we looked after the total numbers of requests every year. That's about 13,500 requests every year. We know that about 1/3 is performed. 1/3 of the people die before the end of the procedure can be reached. And in 1/3 of the cases, we don't know what happens. Maybe the patients say, well, okay, palliative sedation is also a good way for me. Or maybe the patients say, well, I wait for the natural death. But we didn't really know. But it was about 3,000 people that were in that last group. And so we did a feasibility study, and we estimated that about 1,000 people would apply if we founded an end-of-life clinic. And we did. The end-of-life clinic is founded by the NVVE. It started in March 2012. And we started with 6 ambulant teams, and the teams were consisted of a doctor and a nurse. Both are paid, and nowadays they are paid by the insurance companies, the health insurance companies. But that took some time before that was reached. And today we have 38 teams, mobile teams working all over the country. They go to the patient's home if there is a request that is refused by the own doctor. And they listen to the patient, and they see if it meets the criteria of the law, and if it does so, they can perform euthanasia. And I will show you how that works. This is the building where the office is located, and as I told you already, the people with a legal request for euthanasia or assisted suicide refused by their own doctor, they can apply for the Levenseinde Clinic. And how did it work in the first year? As you can see here is the Netherlands. It's only a small country, and these red and blue circles are indicating the number of patients in that region who asked for help from the end-of-life clinic. And these are the women, and these are the male. Oh, no, sorry, the other way around. And in the first year, there were 714 applicants. And what kind of disease did they have? 51% was somatic, 75 had a completed life, 56 were dementia patients, and 254 had a psychiatric disease. And that was a large amount. That is much more than the euthanasia performed or even the applicants in the country in total. And what happened to these patients? Also, the end-of-life clinic rejects, as you can see, 28%. A part is withdrawn. A part died after application, and there were some on the waiting list, and some are in the process. And the number of euthanasia performed in the first year was 104, and that are these two parts. And why are they split in two? That is because half of the 104 was done by the doctors of the end-of-the-life clinic, and the other half was done by the own doctor. The own doctor who was afraid or didn't really know how to perform a euthanasia, didn't know what to do, was helped by the team of the Levensende Clinic and was willing to perform the euthanasia. I seem I'm almost running out of time. What do I expect for the future for the end-of-life clinic? I expect that the number of applicants will increase, that applications are more complex than generally in the country, that euthanasia and psychiatry is hardly developed, and it will take a long time to develop in the end. There is an educative effect. 50% is performed by their own doctor, and the regional review committee of euthanasia in the first year said that all euthanasia applications performed were within the criteria of the law. And already in the first year, the Levensende Clinic was very well established, and a lot of doctors were very happy that the clinic was there so that they could send their own patients to the clinic. And what do I expect for the future of the NVVE? I expect that it must be possible to reach 200,000 members, and that the advanced directives for the NVVE members are a very important product, that there will be more acceptance of euthanasia requests among doctors, but also among the population, and that also psychiatry, dementia, and complete life are situations that are accepted for euthanasia. And furthermore, as I know that euthanasia is performed globally, there will be more acceptance of the right to choose for euthanasia. And that is the moment I had to stop. Thank you.
We have time for some time for questions.
Questions? How about in the way back, in the middle of the back, with the white shirt? Right there?
Yes. Since you are a little more advanced than the rest of us, I'm curious as to how many, if you have data on how many actual suicides outside of this are taking place, and were those people turned down?
Yeah. We have in Holland 1,500 suicides every year, about that number. And remember, we have 5,000 euthanasia performed. That number of 1,500 suicides is not very much differing throughout the years. As we know, for instance, from psychiatric patients that were refused, about 50 of them committed suicide.
Yeah, I guess I'm struck by the definition of the criteria of intolerable and hopeless suffering, and that seems very subjective, and I can imagine there would be many patients who say, my suffering is intolerable, I can't bear it anymore, I want out, and the doctor's saying no. I guess I contrast that with what's been happening in the United States, where it's a little bit more objective. It's not necessarily intolerable, but it's less than 6 months. I mean, do you have cases where the doctors and the patients are not agreeing on what's intolerable? And also, how does completed life get classified as intolerable and hopeless?
Maybe the first question first. Unbearable is the word that's used, unbearable and hopeless suffering. Of course, it's the unbearable word is subjective. Only the patient can feel that it's unbearable. And in medical cases, it's always the patient who decides the pain, the nausea. As a doctor, I couldn't feel the pain of my patient. And if the patient says, I've got a lot of pain, I have to believe him. And that is also in requests in euthanasia. When the patient can convince the doctor that there is unbearable suffering, then the doctor is convinced and can be ready to perform euthanasia. The hopeless part, that is what the doctor also can wait if it's hopeless or not. Maybe there is a therapy, or maybe there is something else to do. I think that the 6 months that are used are much more something on the thumb like that, that you don't know how many weeks, how many days sometimes people will live when they are in a dying phase. Let that be, well, 6 months, no doctor can say that your prognosis is 6 months. No. So, well, I think it's subjective, but it's accepted as subjective. It's not terminal illness that the unbearable suffering needs. Well, it can be every unbearable suffering, and that's also in completed life. We know that everyone who is living, and even the old people that are living and are mobile, they can read, they can hear, they can see, and they can hear, they will never consider their lives completed. But those people, old people, who are not mobile anymore, are not, can't see anymore, can't hear anymore, those people, they have an unbearable suffering.
I have a young friend who is 30 years old, who a little more than a year ago committed suicide because of his unbearable and intolerable, hopeless suffering from mental illness. Would he have been eligible under your system?
That wish of their patient.
One of the most pressing figures there is the rise in terminal sedation, up to 36%. Is there any suggestion that some doctors in the Netherlands are using terminal sedation as an alternative to their patient's request for voluntary euthanasia?
We haven't got hard evidence on that. But I think the answer is yes.
What was the question?
Sorry. The question was the rise of the palliative sedation was up to 36%. That's well, that's a lot. Yeah, when they have a euthanasia request, and I said, well, we don't have hard evidence on that, but I'm sure that that is the case. There are a lot of doctors who, because they don't have enough knowledge about how to perform euthanasia, that they choose for palliative sedation.
I'm a psychiatrist, and I'm kind of intrigued by why people are refused treatment simply because they have a psychiatric illness. Now, people aren't denied cancer treatment because they are psychiatric patients, or they get all kinds of other surgery because they're psychiatric patients. So why should they be denied access to euthanasia simply because they happen to have a psychiatric diagnosis?
That's a good question. That is because in psychiatric disease, psychiatrists are never convinced that there isn't another treatment. And one of the criteria is that there must be no reasonable alternative. So psychiatrists say to a psychiatric patient with a request, well, maybe I have another pill for you, or maybe over 10 years there will be another pill for you, and you're not going to die from your psychiatric disease. So in that, in the lapsing time, I'm going to try to treat you.
I would just like to know how it works when somebody has dementia. It's throughout the advanced medical directives. I was wondering if you can tell us a little bit more about it.
Yeah, that's the advanced directive. Someone with a severe dementia who is not able to express his will anymore. That is in the law that an advanced directive can be in place of the oral request. And so if a patient with dementia has an advanced directive wherein it's written which situation and when he wants to be to have his euthanasia, then a doctor is allowed to perform euthanasia following the law, but it's almost never done.
I believe you'll be speaking about this.
I believe you'll be speaking about this tomorrow at length.
I think, do we have time for one more?
One short question. Can you speculate, or maybe you have evidence, why there are more women that ask for this than men? I saw 60% something for women and 38% for men.
Yeah. That's not a short answer. Why is there a difference between the number of men and the number of women? That is, I think, because there are more older women, and in the number of suicides, men are there are more men committing suicide than women are, and there are more women asking for euthanasia.
I'm sorry that we're out of time. Thank you so much.
Thank you all for an extremely stimulating afternoon. Thanks to all the speakers. I believe this is the end of the formal program for today. There is a meeting for some parties this afternoon and a session with Dr. Sun this evening if you're previously enrolled.